So this has been a lot of heavy lifting. There have been people that have been involved in Florida government and the political scene for like 25 years who've been trying to get legal reform to get us more in line with what works. And, you can see some of these things in different parts of the country. Texas did litigation reform, and they had positive results. Other states, honestly, even states like California have done some that you wouldn't think, but even they have done in certain areas. So that's what you do. Now, these Republicans in the legislature have voted for these reforms, and they've been praised for the reforms. You had a movement in the House of Representatives to undo the tort reforms that have been done and enacted in Florida and that had shown to have produced stability in some of these really, really tricky markets. And it failed in every instance except one to even advance past the House. The Florida Senate said they wouldn't consider it. I was not going to support what they were doing. Now, the one bill that they did was a bill to undo legal reform and tort reform. Not anything that was done under my tenure, though, something that had been done many decades ago in the early 1990s when Florida was facing a crisis in malpractice insurance premiums and lawsuits that were driving premiums high. Physicians were leaving the state. It really had a bad impact on access to care. So the Florida legislature overhauled how medical malpractice actions are done in these instances of the wrongful death. And what they did was they did something that some states also do. I think it's a minority of states that have Florida right now. I think it may have been some more at the time. But what they basically said is, medical negligence, obviously you have a right to go in and get compensation. If something happens to you, of course, you can do that. But they limited two instances to where you could sue for economic damages, but you couldn't sue for so-called non-economic damages. And those two classes were if you had an adult child age 25 or older who was not dependent on a parent with no surviving spouse. If you had an action, that 25 or older independent child could sue and get economic damages, but they could not sue for so-called non-economic damages. And the same would apply if a parent was suing on behalf of a 25 or older minor or child, independent child with no surviving spouse or no heirs. You can sue for the economic damages, but not. And the question is, well, why did they do that? And they did it because when you talk about economic damages, those are quantifiable. You can say you were harmed, here's the damage, and you can recover. When you do non-economic, it is basically what a jury wants to award. Now, that's something that's very appealing if you're a plaintiff's attorney, because if you can get a contingency fee out of a big award, you can make millions and millions of dollars potentially on an individual case. So it was the legislature's view that limiting to economic damages would be a deterrent for cases being brought, across kind of in large numbers, right? And so that had been the law in Florida for many decades. What the legislature did this time is they repealed that portion of the medical malpractice reform. And, for me, I think that if you do, we have a right to expect that physicians are going to meet appropriate standards. There's a lot that goes into it. I mean, the state of Florida provides a lot of support for training physicians and everything. And if somebody is careless, and certainly even worse, there needs to be accountability. But I think the question is in a case like this, what's the best way to do that? Is it to open floodgates for non-economic damages, knowing you're going to get a lot of lawsuits that are going to be brought against a lot of physicians who weren't necessarily negligent, right? Because when you're practicing medicine, you can do everything right, and you may not get a good outcome with the patient. There's not a warranty of cure. These are difficult things. Sometimes there's pluses and minuses for what a physician would do. Physician will consult the patient, tell them that here are the options, and sometimes the patient will opt for a course of treatment or a surgery, knowing that there's high odds that it may not be successful. And all these things are very sad, whether the physician was perfect or whether the physician was not. If somebody doesn't make it through that, that is a tragedy in one form or another. And the loss for a family member, even someone that's an adult and independent at that point, is real. And I think everybody appreciates that. I think the question, though, is what would this legislation do for costs of health care in Florida, access to care in Florida, and our ability to recruit and keep physicians? And I know you're going to hear from people today, but it's their judgment. It's also my judgment that if this legislation would be enacted, it would lead to higher costs for Floridians. It would lead to less access to care for Floridians, and it would make it harder for us to keep, recruit, and maintain physicians in the state of Florida. And we need more as it is now. The state's not shrinking, it's growing, population continues to age. You're going to need more and more there. So what could have been done that would have made this acceptable? Well, I think two things could be done. One is focus on holding the physician directly accountable with regulatory actions. See, you do a malpractice suit, the physician doesn't pay it. It's the insurance company that pays it. So it's not a perfect or even a great deterrent for medical negligence. A third party is paying the costs. We have disciplinary procedures in place, but if there's ways to do that so that folks are held accountable, I'm all for that. The other thing that can be done to prevent this from opening up the floodgates of a lot of litigation is put caps on the damages. If you want to do non-economic damages, put caps on the amount of damages and cap the amount that attorneys can recover. If you do that, then you are totally disincentivizing frivolous lawsuits, because they'll know there's a limited amount that an attorney is going to be able to recover. And if you think about it, if you have no caps on the non-economic damages, that is an incentive to bring a lot of cases, and many of them probably won't be successful, but even then you can probably get a settlement. Again, even if you haven't done anything wrong, there's going to be an incentive to settle, because it's very costly to go through with all this. And then, of course, if you can get a jury to do a big verdict, then the lawyer's going to get a lot of the money there. And sometimes, they're getting 35% of what would be awarded to an individual client, or in this case, one of the relatives. So that will incentivize more lawsuits. I'm very much convinced of that. So I told the legislature this going by, and I know they did try to do a cap on the non-economic damages. So they're opening that up, but capping it, and then also limiting the amount that attorneys can recover. If you did that, I don't think you would see a major impact on the healthcare delivery system. I don't think you'd see a major impact on malpractice insurance rates, and I don't think you would see a major impact on access to care. But the legislature did this years ago for a reason, because they were responding to something that was spiraling out of control, and I don't think that what they've proposed here is going to put us on the strong foot without these additional safeguards. So for that reason, I'm announcing that we will be vetoing that legislation. I have been in contact with some of the legislators, particularly in the Senate. I think the change to do the caps failed by one vote in the Florida Senate, and it was something that was, there's some people that don't want to change this at all, but I think of those people, that's something you can live with if you have some caps on it. So if you look around the country, Florida is a minority that says no recovery in these limited instances for non-economic damages, but the vast majority of state have caps on what can be recovered in terms of non-economic damages. And if you don't have those caps, then you really are incentivizing a lot more litigation to take place in the state of Florida. None of that is free lunch. Somebody will have to pay for it. And unfortunately, I think if this bill became law, I do think the cost would be borne by the physicians who would potentially flee the state, to people that wouldn't have as much access to care, and then also to the cost that would go up as a result of it. And, we consulted a lot of folks that are involved in the healthcare sector, and I think it was pretty much, unanimous that the way this current bill was structured would not have a positive impact on healthcare in Florida, and could potentially have some really significant negative impacts. So I want to appreciate everybody that provided their feedback on this. They were one vote away from doing something that I think was a little bit more palpable for a lot of folks, but it just didn't end up working out that way. So I'm going to let some other